Hello, everybody. This is Allison McLeod, and for those of you who joined me for part one, that we had a great time talking about objectivity, integrity, and judgment. And now in part two, we're going to be talking about independence and conflicts of interest. So for those of you who are just joining us and you don't know who I am, I have spent 18 years in industry. Right out of law school, I was with one of the big four firms for a couple of years, then went to a large multinational corporation, which at the time was a Fortune 50 company, and worked there in tax planning and IRS audits. And then after that, went to another company, an international cement company, as Director of Tax Planning, IRS Audits, and International Tax Planning. And after 3 years there, I ended up going into teaching. And so I now teach full-time at a large university north of Dallas. And I teach tax classes, ethics, in the graduate program. And then they fill out my schedule with some financial accounting classes. And so, but since I've been teaching at a university level, I've also had the great privilege of teaching CPAs across the nation ethics. And this is a topic that is front and center to CPAs because so much depends on CPAs. As we talked about in part one, really, the CPAs are the vanguards. We're the protectors of the accounting rules, and we're protectors of tax administration. And a lot of it is because we can work so independently. Our jobs are so technical and so difficult that most people certainly could not second guess us on decisions that we make on an everyday basis. And frankly, most people don't want to second guess us because our jobs are very, very difficult. So today we're going to be talking about independence and conflicts of interest. And these two are critical items that we as CPAs have to adhere to, and we have to be independent. And one of the things that makes independence so difficult, as we mentioned earlier, is we have to be independent from our client and our employers as it pertains to upholding the accounting rules. And it's an awkward situation because they after all are paying our salaries. But there are times that if the agenda of the client or the employer runs contrary to fair financial reporting or fair tax administration, we have to defy them, and that puts us in a very, very difficult position, and it makes it hard for us to be, I understand why that would cause it to be hard to be independent in those particular circumstances. So that's why this particular issue, plus it's, as we call it, the second cousin here, the conflicts of interest, are highly interrelated, and it's something that's important for CPAs to, of course, maintain in sometimes in the face of hostile circumstances. So today, our course overview, and what we hopefully you'll come away knowing by the time we get done with all of this, will be to have the ability to define independence as promulgated by the AICPA Code of Professional Conduct and understand its importance to the CPA. Secondly, be able to ascertain situations which could threaten a CPA's independence. And finally, that understand how conflicts of interest and the use of contingency fees can subvert this kind of independence. Okay, so that's really what we're going to focus on today. And the one thing that, just for those of you who weren't with us on part one, to let you know what the shorthand looks like for when you designate the AICPA Code of Professional Conduct is ET or code. Okay, that's the designation. And so the AICPA Code of Professional Conduct governs a CPA's ethical and professional conduct. And while they had the major rewrite that was issued at the end of 2014, there was some revisions made, and that was published August 2016, and that is the latest version. But of course, CPAs are not only responsible for being subject to the AICPA Code of Professional Conduct. Clearly, you also have to adhere to your state board rules from the state that you've been licensed, as well as different rules depending on your subspecialty, such as the SEC rules, GAO, and of course for tax people we have Treasury pronouncements like Circular 230, common law, Internal Revenue Code, and regulations, and those types of things. So we have a lot of things that we have to look at in terms of what we're responsible for, and as well, well, let me just put it this way. When I serve as an expert witness for accounting malpractice cases, typically what happens is a lawyer will call me and say, this situation has occurred. Is the CPA in trouble? And I'm happy to say, in some cases, I'm listening to the fact pattern, and the very first thing I'm going to do to find out whether or not you've committed malpractice is I'm going to look at the Code of Professional Conduct. I'm going to look at your state rules. I'm going to look at, Treasury rules if you're a tax person, etc., and the SEC rules if you're a financial accounting or an audit person, and as well as some other sources to see whether or not you have adhered to practice standards. And thankfully, in many cases, the CPA has done absolutely nothing wrong, and that actually makes me wipe my brow, But CPAs typically, when surveyed, and in many studies, CPAs generally know what is the right thing to do to a very high level, and that the question is if put under pressure, are they going to do the right thing? It's not that they don't know the right thing; it's whether they'll do it. And very unfortunately, some studies have indicated that while CPAs know what is the right thing to do, if put under pressure, the CPA there'll be some fall off. So maybe there's a fall off of maybe about 20% of actually doing the right thing if put under pressure. And so therein kind of lies the problem that we have. Thankfully, though, most CPAs do not commit fraud. And unfortunately, they get swept up in other people's lawsuits. In other cases, however, in cases that I've examined, the CPA has violated practice standards, and I'm thinking, oh my goodness, what were you thinking? And they are in a whole lot of trouble at that point. And some of it may be due to a momentary lapse of judgment, and some of it just may be that they were not wanting to lose a client, or they were trying to achieve some sort of economic gain. And unfortunately, it backfires on them, because once you've been involved in a major lapse like that, it is possible that you will lose your license, and on a permanent basis. And that would of course, be a devastating loss, especially if you've built up a practice over a number of years, or you've built up a reputation over a number of years, and you're having to really start over. And so the CPA must tread very, very carefully. Our profession, more than others, has a lot of responsibilities, and simple foot faults could completely disqualify us on a permanent basis for acting as a CPA. And so that makes our job much different than a lot of other jobs where you can make mistakes and yet still move on and stay in the same profession. But with CPAs, we have a lot at stake, and that makes our profession quite unique. So let's go ahead and look at what the AICPA has in terms of what it says that a CPA should aspire to look like. And in this particular case, the AICPA code ET 0.300.020.2 says these principles call for an unswerving commitment to honorable behavior, even at the sacrifice of personal advantage. And we talked about in part one the whole issue of how a CPA sometimes has to pick the public good above the agenda of your client or your employer, or even, for instance, your own agenda. There's a possibility that you may have to go ahead and protect the public's interest, even at great personal sacrifice. And that's what this AICPA code talks about. And I actually appreciate how they've approached this particular version of the Code of Professional Conduct, because they're saying this is what you need to look like. Okay, don't try to parse words. Don't try to, try to adhere to the letter of the law without really adhering to really what is going on. And at the end of the day, honorable behavior is making sure that we, again, fairly state the financial condition of our clients and fairly administer tax laws. So if you kind of look at the situation here of honorable behavior and what's expected from CPA, and you contrast it with what happened in the situation with Enron, you'll see a large disparity. Okay, and one thing that I actually appreciate about Enron situation is the fact that their CFO, Andy Fastow, is now out of jail, and he's been giving a lot of lectures, and what he's been talking about, according to what other CPAs have told me he's said in these lectures has been really enlightening. But first, before I get into what Mr. Fastow is now talking about and how this kind of illuminates the Enron situation, for those of you who are maybe CPAs who were not practicing in the early 2000s, let me go ahead and just enlighten you for a moment about the Enron situation if you've not already studied it in school or what have you. So, of course, Enron was a pipeline company based in Houston, Texas, and was just, it's basically a sleepy essentially a utility company almost, that was just an ordinary company just chugging along. And then all of a sudden, they decide that they're going to kind of transform themselves. And so they got into energy trading. It became a very competitive environment. And they, as part of the company transformation from a little sleepy utility company to really what they hope to be a real powerhouse in energy trading and a lot of other types of related businesses, was they hired a CFO by the name of Andrew Fastow, whose background was not accounting. His background was actually investment banking, and his role and his goal was to basically find ways of improving the Enron stock price. And so as part of the many things that went on with Enron and its finances and some of its operations and whatnot, Fastow and his group managed to get permission from the SEC to use what's called mark-to-market accounting. And mark-to-market accounting, there's a lot involved with it, but as it pertains to Enron, what it meant for them is that if under normal mark-to-market accounting rules, if you have an idea that could potentially lead to a stream of revenue, okay, or you have some type of like IP or something like that could lead to a stream of revenue. Under very, very limited circumstances, you could go ahead and capitalize that to the balance sheet, and to a certain extent, there potentially could be some revenue recognition as well. And I think mark-to-market accounting is only supposed to be used in very, very limited circumstances when the possibility of benefit is far more assured, but of course, once Enron had gotten a letter from the SEC to say that you could use mark-to-market accounting, then they basically proceed to use it and to capitalize any half-baked idea that they had come up with. And so they were capitalizing all sorts of crazy things to their balance sheet and recognizing all sorts of phantom revenue that potentially was not going to occur, and indeed in most cases did not occur. And as well, the other thing too was Enron had a whole lot of debt on its balance sheet, and it was really weighing it down. So one idea that they had was, of course, if you all are familiar with the story, they ended up taking a lot of this debt and they ended up throwing it onto some JVs that they had formed. Now, of course, these JVs were quite related, but they ended up had the result of it not. If the debt was in the JVs, it wasn't going to end up being consolidated onto their financial statements. It was what was called at the time off-balance sheet financing. And so from the outside, it seemed like a kind of a clever move because it had the effect of taking a bunch of debt off their balance sheet and improving, of course, their equity position. But if you kind of looked at things from a 30,000-foot level, it was obvious that what they were doing, while it may seem to follow certain quote-unquote rules, that at the end of the day, Enron was not properly accounting and not properly reflecting its financial condition. In fact, its balance sheet and its income statements were completely false in terms of reflecting what Enron's financial condition was altogether. And but Fastow said that his goal was to increase the stock price, and he thought they were, quote unquote, being legal. They were looking, felt that they were following the rules, but of course they had lost sight of what is the company's true financial condition. Am I showing that to all the stakeholders, including investors and employees and banks and all that kind of stuff? And of course they were not. Now Fastow, as I said, was released. He ended up ultimately, as Enron collapsed, a good number of executives were arrested and convicted of fraud. Fastow ended up with, I think, a 10-year sentence, which I believe he served most of it. I recall that he was probably released a little early on good behavior or whatever. But in recent years, he has been speaking to a lot of different financial groups like FEI or what have you, and talking about his experiences at Enron and what their thought process was and where they went terribly wrong. And I've had CPAs who've gotten to hear him speak as he's come into my region a number of times. I've never gotten to hear him myself, but what they say he talks about was when they got arrested, he was utterly shocked because he thought they were being completely legal. But in reality, again, there was a complete misstatement of Enron's financial condition. And as a result, that Enron totally collapsed. And along with that, because many of the employees had their 401ks in Enron stock, of course, those employees not only lost their jobs, of course, they weren't going to get a pension because Enron was defunct, or if they were going to get a pension, based on the receivership of that pension plan, it wasn't going to be very much. And of course, their 401ks were completely gone because they were all in Enron stock, which was now down to zero. And so, it was really a devastating situation for the employees, and not just the employees, but the employees' families who depended on their jobs, and as well, not even to speak of the banks who lent Enron a lot of money, the shareholders who lost their money as well. And it was a terrible situation all the way around. And if you kind of look at being quote unquote legal, as Fastow talked about, versus being honorable, there is a great divide in that particular case. And so, CPAs need to not just say, oh, am I going to go ahead and meet the letter of the law? That may be the first question you ask, but you've got to ask the second question, which is, let's take the long look at this. Let's take the 30,000 foot look at it. And are we really doing the right thing? Not just meeting the letter of the law, but are we being honorable? Okay. And then this is something that the AICPA code requires of us. So let's look at independence. So independence is not just independence in appearance. Okay. So you have to look independence, but you also have to be mentally independent. I know that sometimes it takes a great deal of moral courage to defy, for instance, you may be in a difficult, toxic situation. I've recalled situations when I was in industry where I had an unpopular view, and there were 8 people around me saying, no, you need to go along with us on this particular case, on this particular situation. And, I was firmly convinced in my view, knew that I had a lot of backup and a lot of authority from, the tax law to maintain my viewpoint. But my viewpoint was getting in the way of other people sort of achieving certain agenda items of their own. And so, I've been there when there's been a lot of pressure on the CPA to cave in particular circumstances. And it's hard, again, especially if someone else is paying your salary. It's your boss that you're maybe even defying. But as CPA, we have to be independent in mind, and we have to know that, we have to go ahead and show that professional skepticism and maintain it, even in the face of potentially negative consequences to ourselves, by defying these employers or clients. And so we have to be independent in mind, knowing that we have to think outside of, maybe the group think. And we also have to look independent as well. So how it looks is also very important.